Let's rewind for a second. Remember how gun carry rights were treated for years? Not like a constitutional guarantee, not like something rooted in history or responsibility, but like a privilege you had to beg for. A favor, one the system might grant you if you jumped through enough hoops, paid enough fees, filled out every form perfectly, waited months, and hoped nothing got lost in the process. You could pass every background check, train harder than required, follow every rule down to the smallest technicality, and still be treated like you were asking for something dangerous, something suspicious, something you had no business wanting in the first place. Meanwhile, entire cities quietly turned into invisible no-go zones. Places you walk every day, parks, trails, public spaces, whole stretches of downtown. These weren't just restrictions. They were psychological traps designed to make you unsure, hesitant, second-guessing whether caring for your own safety was even worth the risk. And deep down, everyone knew that was the point. Confusion was the old playbook. Make it so complicated, so intimidating, that eventually you'd give up on your own rights without them ever having to say the word ban. But not anymore, because a new ruling just tore straight through all of that. Clean, direct, undeniable. A massive two-way victory that didn't just adjust the rules, but crushed an entire mindset that lawmakers quietly depended on. The era of subtle suffocation is being ripped open, and for the first time in years, the momentum isn't against gun owners. It's finally shifting in our favor. For years, lawmakers used a trick so subtle that most people didn't even notice it happening. They didn't outright ban gun carry, not boldly, not publicly, because they knew that wouldn't survive a constitutional challenge. Instead, they strangled it slowly, quietly. They hid restrictions under layers of red tape, mapped out complicated off-limit zones, rewrote definitions, invented new conditions, and turned what should have been a basic right into a bureaucratic maze that no ordinary person could navigate without fear of accidentally becoming a criminal. It wasn't just inconvenient, it was deliberate. And the moment you stepped back and looked at the pattern, it became obvious. The goal wasn't safety. The goal was surrender. They wanted you overwhelmed, confused, unsure where you could legally walk, drive, or even stand without risking a technical violation. That was the playbook. But this new ruling didn't just hit pause on that strategy, it shattered it. Because when the court struck down the carry ban, it didn't do it half-heartedly. It didn't issue a soft warning or a gentle correction. It did it with force, clarity, and a historical grounding that shut the door on every flimsy argument officials had been recycling for decades. The judges didn't ask vague questions about intentions or safety claims. They asked something far more powerful. Where in American history was the right to carry a firearm treated like a conditional privilege? Where in the founding tradition did ordinary citizens have to navigate a patchwork of invisible borders just to protect themselves? And when the state couldn't answer, even after years of defending the ban, the ruling practically wrote itself. What collapsed wasn't just a single restriction. It was the entire narrative that the government could keep squeezing gun owners by playing hide-and-seek with public space. The impact rippled instantly, and the first place where that shockwave became impossible to ignore was Tennessee. Officials there had mastered the art of pretending they were protecting the public while quietly carving huge portions of daily life into off-limit zones. Parks where families walked, trails where joggers trained, public areas where people gathered, all labeled as places where your rights simply didn't apply. It wasn't a ban, they claimed. It was a reasonable limitation. But to anyone paying attention, it was obvious. They weren't banning guns. They were banning confidence. They were making the rules so confusing, so contradictory that you'd think twice before carrying at all. But then came the judge who refused to play along. He peeled back the arguments, ignored the emotional packaging, and asked the only question that mattered. What's the historical basis for stripping a citizen's right to bear arms the moment they step into a park? And when the state had no answer, because there is no such tradition, the ban collapsed under its own weight. One ruling, one map redrawn, one illusion destroyed. But that wasn't the end. It was just the opening shot in a chain reaction. Because next came Minnesota, and this time the target was an entire generation that had been told for years that adulthood was somehow negotiable. 18, 19, and 20-year-olds were expected to vote, pay taxes, enlist, deploy, and carry more responsibility than most adults twice their age, yet were still barred from carrying a firearm for their own safety. It wasn't logic, it wasn't law, it was dismissal dressed up as regulation. But when the lawyers challenging the restriction walked into the courtroom, they didn't bring emotional testimonies or political speeches. They brought history, documented, undeniable proof that in the founding era, young adults were not only allowed to bear arms, they were required to. They were part of the militia. They were seen as responsible citizens, not sheltered children. And once that historical record was placed on the table, the age restriction didn't just weaken, it broke completely. Overnight, millions of responsible young adults stood on the same constitutional ground as everyone else. It was a reminder that rights don't age in gradually. They exist, period. And then came the shocker, the one almost no one expected. Washington, D.C. For years, the city operated like a trap. One wrong holster, one outdated permit, one misunderstood rule, one administrative error, and suddenly a law-abiding citizen was labeled a criminal while actual criminals roamed without fear. D.C. perfected the art of weaponizing technicalities. But once the Supreme Court's Bruin standard locked into place, everything changed. Judges started pushing back. Defense attorneys began winning cases they would have lost instantly just 5 years earlier. And behind the scenes, prosecutors who had once aggressively pursued even the smallest carry violations began quietly dropping cases. No announcements, no press releases, just silence and retreat. When even D.C. stops playing the game, you know the balance of power has shifted. The pressure isn't on gun owners anymore. It's on the people who spent years trying to trip them. But all of that was just the warm-up for what came out of California. The state that built its political identity on strict gun control. The state that created more restrictions, more delays, more limits, more hoops than any other place in the country. The state where gun rights cases went to the Ninth Circuit to die. But this time, something different happened. When the court reviewed California's long-standing purchase limit, it didn't stall, didn't drag its feet, didn't look for a compromise. It struck it down fast, hard, direct. It issued a mandate that didn't leave any room for loopholes or slow, quiet re-implementation. A clean break, a dead law, and that moment mattered more than the headlines suggested. Because if California, the strictest state in the country, couldn't defend a restriction under the current constitutional standard, no other state could either. The myth that some places were untouchable, that some courts would always side with restrictions, shattered in an instant. It wasn't symbolic, it was structural. A pillar of the old system cracked, and the rulings kept stacking up. Case after case, judge after judge. What used to be isolated victories turned into a pattern that couldn't be ignored anymore. The old playbook, confuse, delay, restrict, pressure, was falling apart because courts were no longer looking at what lawmakers claimed they were doing. They were looking at why. They were asking, is this law rooted in historical tradition? Is this restriction grounded in the founding era? Is this policy actually about safety? Or is it about control? And every time a state tried to hide a new restriction behind a fresh title or a softened description, it backfired. Judges saw through it, the credibility vanished, and the next ruling cut even deeper. But the most important impact wasn't in the courtrooms. It was in real life. In the daily moments when ordinary people finally felt the difference. The young woman locking up her shop at night in a rough neighborhood, no longer forced to choose between following the law and protecting herself. The college student who had been told he was too young, too immature, too irresponsible, now recognized by the courts as an adult with full constitutional rights. The father driving across states with his family, terrified that crossing an invisible border might turn him into a felon over a technicality, now protected by a standard that prioritizes rights over paperwork traps. These aren't legal changes, they're life changes. They show up in commutes, in late-night walks, in long drives, and decisions that people make every single day. And when you step back and look at the momentum, it's undeniable. One victory could have been luck. 2 could have been coincidence. 3 could have been timing. But when win after win after win stacks up, even in states where gun rights used to have no chance, that's not random. That's movement. A constitutional recalibration years in the making. And yet, even with all these wins, one thing remains true. None of this means anything if gun owners get complacent. Rights don't defend themselves, court rulings don't enforce themselves, and victories don't last unless the people who benefit from them stay informed, disciplined, and ready. That means checking your permits, knowing your state lines, understanding how to transport legally, keeping your ID handy, saving the number of a self-defense attorney, not out of fear, but out of responsibility. Because clarity beats panic every time. And the truth is, the people who spent decades building those restrictions aren't backing down quietly. They're regrouping, they're rebranding it, they're trying new language, new strategies, new ways to package the same old control. But this time, their tactics aren't slipping by unnoticed. The courts are watching, the public is watching, and for the first time in years, the momentum is on our side. What comes next depends on whether gun owners stay sharp, stay consistent, and stay engaged.